Good morning, everybody. Chris is busy being a lawyer, so we're not going to have Chris today. And Brian's on a plane headed to Texas. So you got stuck with me and the guys from California. Just to let you know, we had a great call earlier. If you did not get to be on the call with us, it will be available as soon as I can get the guys to land and stop doing what they're doing. So it'll be later in the week, possibly the first of next week. But we will have another call on June the 13th because the first week of June was just not going to work out. So just be aware, and I will send information out on that. So I am going to pass this over to Matt. Matt, take it away.
Great, thank you. So basically, since the last time we met, there hasn't been a whole lot that has been going on in California that I would say is sort of new. A lot of the stuff that's been happening continues to cause problems. For example, people getting COEs and things like that, which we've talked about, I think, ad nauseum for the most part. What really has happened since the last time we met is that the ATF has released its final rule for the definition of framer receivers, which includes various other changes to federal regulations, which I'm sure was talked about in more detail in the federal webinar earlier as well. But in reality, because this is getting changed at the federal level, this is something that is going to affect California dealers that they obviously should be aware of, specifically as applied to the actual definition from ATS standpoint of firearm frame receiver. They're also amending the definitions for things like firearm itself, gunsmith. They're providing new definitions for various terms such as complete weapon, complete muffler, silencer, multi-piece framer receiver, privately made firearm. And of course, I think the one that everyone's going to be focusing on is the new definition of readily, as applied to things like 80% receivers, which in California, as we've talked about before, the California Department of Justice has adopted a regulatory scheme for what are called firearm precursor parts. That is something that is currently scheduled to take effect on July 1st. And as I mentioned previously, we were sort of waiting for regulations from the California Department of Justice on what exactly is a firearm precursor part. And of course, the ATF was sort of slow rolling its own regulations on sort of the same subject. And so I think the California Department of Justice, knowing that the implementation date being July 1st, and the fact that the ATF hadn't yet published its final rule, they basically took what ATF had written for its proposed rule and put that into its emergency regulation package, which has now been adopted and now scheduled to take effect, of course, on July 1st. And so that same definition, for example, the term readily, as far as what constitutes a readily convertible object to be made into a firearm, is something that the California Department of Justice has adopted. Of course, the big problem that I have with this, and I'm sure a lot of you have questions on, is there's no way under California law, California regulations, to request sort of clarification from the California Department of Justice as to what exactly constitutes a firearm precursor part. At least at the federal level, there is a mechanism. You can submit what's called a determination request, where you can submit a letter to the ATF and basically just ask them, you know, what is their opinion on whether or not a particular object is a firearm or not, or something that's regulated by the Gun Control Act, the NFA, whatnot. So there is a mechanism under federal law which you can do that, but of course under California law there is no such similar mechanism. And the way that the California Department of Justice has adopted these regulations, being a carbon copy basically of what the ATF is doing, is going to cause a lot of problems, a lot of confusion. And so if you're interested in selling what are considered firearm precursor parts, generally, of course, we're talking about things like 80% receivers and stuff like that, there could be quite a few issues that start taking effect here on July 1st. We will be putting together some more information on that, and we'll be sending that out through FFLGuard as soon as we have a chance to review everything. Obviously, the ATS proposal was just released. It's about 300 pages, so there's quite a lot to go through on that, and so we will be putting out more information as it becomes available to us. The other thing, California, of course, that Chuck isn't here, I'll mention briefly, and he's talked about before. We are expecting a decision from the United States Supreme Court any week now regarding the New York State Rifle and Pistol Association v. Bruin case, which is currently before the United States Supreme Court. Of course, the thought is that that will drastically change the sort of framework that we have for firearm-related cases, not just in the United States, but in California specifically as well. And so we, of course, have a number of cases that are currently pending that are basically on hold, waiting for that decision out of the United States Supreme Court. That includes the challenge to the restriction on magazines capable of holding more than 10 rounds, the carry restrictions in California, the good cause requirement, things like that, California's assault weapon restrictions, all that stuff potentially is on the table, again, depending on what the Supreme Court does with that decision. And so we're just waiting, of course, for that. And so, like I said, it's quite possible that it could be coming out here any week now. And so the CRPA and FFLGuard will be putting out information as soon as that hits. We're just waiting to see what the actual language is from the Supreme Court. It will, of course, it sounds like it's going to be a favorable decision. We just don't know to what extent yet. So with that, that's all I had for today. Josh, if you'd like to add your part.
Sure. Good morning, everybody. Happy 2nd of May. One of the things that we're continuing to see a trend with firearms retailers here in California is there are a couple of law firms that are going around, and for those retailers that actually have a retail storefront, they're going in and they're doing spot shopping checks and then using that as a basis to bring Prop 65 actions. And I've previously talked to you guys about it before, but I wanted to sort of give you an update and a refresher on it, because, you know, this is something where any technical violation opens you up to liability. And it's not an insignificant amount of liability. It's just enough liability to make your Christmas not very good, but not so much liability that you're not going to pay it. And it's designed that way. And so I want to try to help you folks avoid that as much as possible. So briefly, all of you folks in California have seen the ubiquitous Prop 65 signs that have been around for decades, that basically you're walking into a parking garage and it says, "This facility contains chemicals known to cause cancer in the state of California." And you're like, okay, great. What do I do with that information? Absolutely nothing. And the reason those signs ended up there was for a period in the late 90s through the mid 2000s, there were a whole bunch of plaintiffs' lawyers going around just finding different facilities, businesses, and if they could show that there was any trace of any carcinogen that was being used, they were going to fast food restaurants. I handled a couple cases involving gas stations because there weren't signs posted to let you know that you were being exposed to chemicals in the gasoline that were known to cause cancer in California. At one point, it got silly enough that they were suing hotels and apartment buildings for not having it posted in common areas where people might smoke cigarettes. So at some point, everybody got fed up enough that they got a change to the law. And so now, beginning in August of 2018, we no longer are supposed to be using the ubiquitous, completely unhelpful, "there's something in here that may cause cancer" warning. Instead, retailers are required to post very specific signs for specific products. Now, I say retailers are supposed to do it, but the way it's really supposed to work is unlike the old model in which everybody could get sued. Technically, manufacturers are the ones on the hook, but what we're seeing is that retailers are getting sued anyways, even though manufacturers are on the hook. And so here's the basic requirement. You're obligated now to, for every product you have that has a carcinogen or what's called a reproductive toxicant, something that causes birth defects. For every product that you have that has that chemical in an exposure amount that the state considers to be enough to cause cancer, you have to have a specific warning on that product. It does not matter if that product was bought in the state or bought from out of the state. And this has been a big issue because you have a whole bunch of out-of-state manufacturers who supply things like fishing creels and ammunition and all these things where they're now obligated if they want to ship their products into California to include a Prop 65 warning on it. and it's very specific language. There is a memorandum that FFLGuard has published that talks about the specific language you need. But initially, manufacturer is responsible. Now, that being said, retailers can become responsible for having to label. And like I said, even though manufacturer is responsible, and we'll talk about it in a second, we're still seeing them getting sued along with the distributors and the manufacturers by these Prop 65 mills. But it's a specific warning. You either have to put it on the packaging or you have to put it on a shelf tag next to the product on the shelf, specifically identifying the product. So if it's, Remington 223 ammunition, it's got to say Remington 223 ammunition, and then the warning. And usually for all those, for firearms dealers, we're usually seeing lead as the warning. But if you're selling other sporting goods stuff, like, we're seeing a lot of lawsuits against different types of plastic fishing equipment, plastic hunting equipment. We've seen lawsuits against, like I said, creels, canvas bags. We've seen lawsuits against not ammunition yet, and that's a strange one, but holsters. We've seen some lawsuits against dealers for not labeling holsters with the Prop 65 information. But so the manufacturer is supposed to either give you this information on a sheet that says, here we're shipping you a pallet of product or a couple different products. For this product, here's your Prop 65 warning information. For this product, here's your Prop 65 warning information. For the third product, there's no Prop 65 warning information needed. That's one way manufacturers can do that, which then shifts the obligation on retailers to make sure that they've seen the warning sheet and that they're properly putting the labels up on the shelf. Otherwise, it's supposed to be printed right on the outside of the package by the manufacturer. However, as manufacturers, particularly those out of state, are trying to figure out their ways to wiggle out of this, sometimes what they'll do is they will say, okay, retailer, we're going to make you responsible for identifying and labeling all the Prop 65 warnings, which is kind of hard for a retailer. And one of the original reasons they changed the law and put more emphasis on the manufacturers being liable is because the manufacturers know what's going in the product and the retailers don't necessarily do that. But manufacturers can contractually shift their liability to the retailers, and some of them have been trying to do that and have been getting away with it. The other way that retailers can be directly responsible is if it's like a white label or a retailer branded product. So you go out and you get a supplier to create you a white label product and you turn it into whatever your store's names is, brand of fishing tackle or brand of ammunition, or so that's the other way in which the liability won't be with the manufacturer there, but will be assumed by the retailer. Now, I've told you all this, and then I said retailers are still getting sued. Well, what does that mean? Well, when the Prop 65 mills do these spot shoppings, identify a product that they claim and supposedly have testing to support contains a carcinogen at an inappropriate exposure level, they will sue everybody in the chain of sale. If they will sue the manufacturer, they will sue the retailer. If they can figure out who it is, they will sue the distributor. And they'll basically let you fight amongst yourselves as to who's supposed to pay them off. Typically, these cases settle for anywhere from about $15,000 to $25,000 or $30,000, but this is per product. And understand that all that has happened in the case is that a warning letter was sent, because they're required to do a pre-litigation warning letter that gets sent also to a state agency, and they filed a lawsuit. And that's all they have to do to get you to the point where you're arguing with your distributor and your manufacturer over who's going to come up with the $15,000 to $30,000 to try to settle this. And that's where this whole issue of, well, did the manufacturer contract with the retailer for the retailer to take on the responsibility, ends up, becoming an issue. So there's a couple different ways you can protect yourself on this. One is to make sure you train your warehouse staff or your sales staff that if to be checking all the packaging and making sure there isn't a list of Prop 65 warnings that came in that somebody in a warehouse overlooked or threw away, thought it was part of a shipping manifest and just threw it away. Well, no, the manufacturer is going to later claim when everybody gets sued, well, we sent you guys the warning sheet. It was right there. It was taped into the top of the shipment. Well, that's our standard practice, and you guys didn't put it out, so you should be responsible because we complied with our obligation on our end. The other thing you need to consider doing is including a terms and conditions sheet whenever you send a purchase order off to a distributor or manufacturer. And that's certainly something that through the help desk we could help you with. But essentially what you're doing is when you're sending an order, you're also sending a sheet that says, by the way, this order is going to be subject to the following terms. You're the ones, manufacturer or distributor, who are going to be responsible for complying with Prop 65. We're not going to take on any obligation to do that. If you decide you're going to fulfill your obligation by giving us the information to put on shelf tags, you're either going to provide us the shelf tags with these specifications, or alternatively, you're going to make sure that you give us a separate alert that you're doing this so that we don't overlook it. So that's one of the ways retailers can protect themselves. You can even put an indemnity provision in there. Some of our bigger retailer clients have been able to get away with that with some of their distributors, basically shifting. So when the lawsuit happens, they can automatically turn to the manufacturer and go, well, not only is this your fault and your fight, but I've got an indemnity provision in my terms and conditions that says from $1, you're defending me over this product. So go deal with it. Come back and let me know when you've settled the case. Otherwise, what we've been seeing is that sometimes manufacturers will hem and haw, and they'll go, well, we want to fight this case, and there's no advantage to fighting the case. The only advantage to fighting these cases is that if you have a particular plaintiff's firm and you want to, then they filed a bunch of lawsuits against you as a particular retailer, and you want to discourage them from doing it. That's the only time that fighting these cases makes any sense money wise. Otherwise, you just, if you get one or two of these, you just pay them off, because there's no attorney fee recovery provision if you somehow happen to prevail and show that, either the product didn't have the carcinogen in it at the level required for a Prop 65 warning, or alternatively, you did comply. It's just not worth it. And then the other thing is, your remedy as a retailer is to defend the case and show that the manufacturer is the only one that has liability. And maybe even chase after the manufacturer for any costs you incurred in defending the case. But when you get swept up as a retailer, along with the distributor and the manufacturer in a Prop 65 case, you really don't have any recourse against the plaintiff in that case, other than to defend the case and walk away. And then you will spend a bunch of money doing that. You'll spend way more than $15,000 to $25,000, that's for sure. And you can only look to the manufacturer, the distributor, to try to recoup at that point. You've got nothing against the plaintiff. So it's very, very important that you guys try to take steps to one, ensure that, if you do have shelf tagged obligations because of what the manufacturer sends you, that you're complying with that. I'll leave you with this on the Prop 65 issue. You guys can do everything absolutely right when it comes to Prop 65. You can label all the stuff, that it has carcinogens. You can make sure that all your warehouse and sales staff are trained with regard to, reducing liability, shifting liability. But the way these Prop 65 cases work is that sometimes the plaintiff's attorneys just flat out lie. And they will claim that they have testing for a product that shows an exposure level to a carcinogen on the state's list that's above the acceptable level. And so therefore, you should have had a Prop 65 warning. And neither you nor the manufacturer had any clue, because as it turns out, no, that chemical's not in there at that exposure level. But you would have to go out and hire your own expert to interpret the manufacturer's testing results to show that no, this isn't in the exposure level necessary to post a Prop 65 warning. That takes a lot of money, and that may happen to you regardless of whether you do everything right. So I just want to give you a heads up. But that being the case, the idea here is to reduce your exposure to these as much as possible. So again, consider a terms and conditions list. Make sure everybody's trained on what their Prop 65 obligations are. Everybody's looking at all the papers that are coming in with the product that's being shipped in, that you are establishing and having communications with your distributors and manufacturers such that they understand that you don't want to take on this liability. So that, even if you're sending a terms and conditions sheet, it's not a surprise. you're having conversations with your manufacturers so they understand they have this obligation. We're still encountering manufacturers outside the state of California who don't understand they have this obligation. And someday this may be ripe for what's called a dormant commerce clause challenge, whereby, you know, one of these out-of-state manufacturers says enough is enough and then sues the state of California, claiming that this interferes with interstate commerce under a federal claim. I don't know when somebody's going to be incentivized to do that. That's another expensive lawsuit, and it may or may not win, but that may be coming down the pike. But until then, like I said, try to have these communications with everybody, make sure everybody understands, and work up a terms and conditions sheet. And if you have any questions about terms and conditions sheet, you know, feel free to put those questions to the help desk, and we can talk to you about that. Okay, so the second issue was I was out last week in Texas, and when I got on the plane, there was no mask mandate on public transportation. And then on the way back, I got news that LA County had reinstituted a mask mandate on public transportation. I got off the plane and nobody was wearing a mask. And nobody in the terminal was enforcing it, and nobody on the shuttle back to the parking lot was enforcing it. Even though this April 22nd LA County order said, no, if you're on public transportation and Ubers and airports and things like that, within LA County, you have to comply with our new mask mandate. So I thought I'd give you guys a refresher in light of sort of this changing field of where it got blocked federally, but now you see counties like LA County coming back and maybe tweaking some of their COVID regulations. What you guys still have to do now as employers and as retailers with regard to employees and customers. Well, I mean, the good news is that even if you're in LA County, their April 22nd order that reinstituted mask mandates on public transportation and in airports and other public buildings did not extend to retail establishments. So for whatever reason, when they decided to double down, they did not double down by reinstituting mask requirements that are different from, or I should say more onerous than, the ones you guys are obligated to follow under Cal OSHA regs. And so just as a reminder of what those regs are, they're still the same as the last time I reported on them, but you got to allow your employees to wear masks if they want, but you don't have to have them wear masks, and you don't have to worry about vaccinated versus unvaccinated anymore. You do have to supply masks or respirators to your employees if they request them. You have to provide testing for any exposures or outbreaks you become aware of. You have to provide notice to the exposed people, as well as you have to report exposures and outbreaks. You have to accommodate both customers and employees with medical conditions that don't allow them to wear a mask. So bear in mind, remember, we talked about those fake ADA mask cards that came out early in the pandemic. Well, now if people are claiming that they have a medical condition that doesn't allow them to wear a mask, you're allowed to ask a couple follow-up questions to make sure that that's right. But if they require an accommodation, they require an accommodation. But again, you don't necessarily have to make anybody wear a mask. You're welcome as an employer to make people wear masks, but you're not obligated to make them wear masks. And finally, and the most fun part of this, as the state government slowly squeezes away at the middle class and the small business owner, you have to give COVID leave and 40 hours of supplemental pay on an employee's say so that they have COVID. And then you have to give them another 40 hours of paid leave if they then provide you proof for the second 40 hours. So the first 40 hours is a free vacation because they go, I have COVID. The second one, they at least have to give you a doctor's note. And that's all I have, guys. I hope everything's warming up in your area, and great to talk to you this month.
Thank you, Josh and Matt, for all that information. I'm going to add my 2 cents again, like I did on the last call. Please make sure that your employees are being reminded, I recommend on a monthly basis, just to keep it fresh in their head, what to do if the ATF calls or if the ATF walks in. This is a good time for you just to check off a box that you're going over policies and procedures with your individual employees. Some people learned this when they first started 5 years ago. They might have forgotten. So make sure you're talking to them about it on a regular basis. That way it's second nature to them. Other than that, we will be having our next call on June the 13th, and this will be available probably the first of next week once I can tie down Chris or Brian to get it moved over to YouTube. So other than that, thanks for stopping by. I don't think we had. Oh, you got a question? Okay, what you got?
This is for Matt. I just put a message up there. If they're a 15-hour employee, is it still 40 hours? I mean, for Josh.
Josh, you're muted.
You're muted.
Sorry, what was the question? Okay, if they are a 20-hour employee, is it still paid? No, it's pro rata. It's
So
pro
whatever
rata.
their averages is what they get?
Right, correct.
Okay. Okay, perfect. Thank you.
Yep.
Okay. Other than that, does anybody else have any questions? All right. That was a great 30 minutes. Thanks everyone for being here, and we'll see you in a month and a week. Bye.